A very good evening to you out there, wherever you are watching from. It may be afternoon or it may be morning, but a wonderful day to you out there. I am Chief Robinson Ariyo. I am the Egungun of Warri Kingdom. I am a legal practitioner, a public affairs analyst, and a development practitioner. I have come today to assist us in putting some records straight. It is rightly said in intellectual circles that the illiterates of the 21st century are not those who cannot read and write, but those who cannot learn, unlearn, and relearn. So in the next few minutes, I'm going to challenge some of the things that we think that we know with credible and verifiable pieces of evidence. I am talking particularly about the delineation palaver that has bedeviled the Warri Federal Constituency for the past 3 years, as a lot of you know. However, the history of this quagmire began way back in 1996, more than 24 years ago. I'm talking about the book, INEC and Corrupt Practices, the Siamese twins and Warri Federal Constituency. It is now in the market. It was launched just last week, Saturday. And the purpose of this outing is to make us understand what is contained in this book. As a student of philosophy, I enjoy syllogism, I enjoy presentation with logic. And as a student of literature, I enjoy storytelling. So I'm going to combine those two backgrounds of mine in telling you a little story about this book, which I believe you will enjoy. Now, many of us hear about the delineation palaver. Do we really know how it came about? You will know. Way back in 1992, the federal government of Nigeria did the delineation of wards across the 774 local government council areas in Nigeria, including those in Warri Federal Constituency. Now, by the provisions of our Constitution, delineation can only be done after 10 years. In other words, if delineation was done in 1997, the next time legally to do delineation exercise will be in 10 years after 1997. In this case, delineation was done in 1992. And the Federal Gazette, the federal document containing the composition, number, and structure of wards across the country, including Warri South, particularly that of Warri South, is contained in this book as an annexure. It is the Federal Government Gazette of 1992. Now, this is where the problem started from. There was an attempt by the then NECON, before INEC was NECON. NECON is Nigerian Electoral Commission of Nigeria. Now, National Electoral Commission of Nigeria, which then transformed into INEC, Independent National Electoral Commission. So, in 1992, when the federal government created all the wards, number, and structure across the country, Warri South had 10 wards. I repeat, Warri South had 10 wards. Of these 10 wards, you had 8 of them being predominated by persons of Ishekiri ethnic extraction. Now, this did not go down well with the leaders of a couple of other ethnic groups across the state. And so in 1996, they induced the Electoral commission to gerrymander Warri South. What do I mean by gerrymandering? Gerrymandering is the process of partitioning a political area in such a way as to disfavor certain components and favor other components. And so what they did then was to get the electoral body to increase the number of wards from 10 to 12. Hence you hear 10, 12 ward controversy. In doing this, they reduced those predominated by Shekiris to 6 and increased those predominated by the Robos from 2 to 6 and created a pseudo sense of equality. Now, this did not go down well with the Shekiris then. And as at that time, it was Dr. Joseph Otumara that was the chairman of Warri South. He led the other councillors, including Griffin and Philip Ejeyi, and a couple of others, to the Federal High Court, where they challenged that decision based on the constitutional provision. In 1997, they obtained an order of interlocutory injunction restraining INEC from giving effect to the 12-ward structure. Now, despite the fact that that order was made, INEC did not obey the order. And that is where this whole disobedience of court orders started from. So you can imagine that this whole palaver did not just begin now. It started more than 24 years ago. And so when INEC refused to listen to the order or obey the order of the Federal High Court, the team led by Chief Dr. Otumara, it was then not a chief, but a medical doctor and the chairman of Warri South Local Government Council area, pursued their case until 2003 and got a final judgment. A copy of that final judgment is also contained in this book at the appendix. Now, the wordings of the final judgment is quite interesting. It goes thus, that the delineation of Warri South from 10 to 12 is illegal, unlawful, null, void, unconstitutional, and of no effect whatsoever. And one would have expected that with that judgment, the judgment of a competent court of law, a court of record, the Federal High Court in Benin, then, that INEC would have begun enforcing the judgment. Again, those who are prepared to make trouble in Warri induce INEC to pretend, I say pretend, to appeal against the judgment. I say pretend because INEC did nothing more than just file a notice of appeal and did nothing about it. Now, it's elementary law that when a judgment has been delivered, that judgment becomes operational until it is set aside. And the effect of that judgment will continue to reign until there is a stay. What INEC did was it only filed a notice of appeal. It did not even process the appeal. And eventually, for want of diligent prosecution, throughout this period, INEC did not do anything about the appeal. Again, those who filed the action and got judgment, whom the law will consider, will name as judgment creditors, INEC being the judgment debtor, they went to court. That is, the judgment creditors went to court and asked the court that the court should strike out the appeal for want of diligent prosecution. And the effect of that is that of dismissal, because you can't come back if you are not diligent in the prosecution of your appeal and it is struck out. So the appeal was struck out in 2018. Between 1997, when the interlocutory order was made, and 2003, when the final judgment was delivered, and 2018, when the appeal was finally struck out, INEC did not obey judgment. So when you start hearing INEC portraying itself as an obedient servant to judgment, you will wonder whether there is a different INEC, or there was a different INEC in 1997 and a different INEC in 2002. Now, in 2018, like I said, the appeal was struck out, the effect of which was a dismissal. INEC did not do any other thing. So in 2019 cycle of election, when INEC was still now proceeding to conduct election on the basis of the word structure and number that had been declared illegal, unconstitutional, null and void, the Shekiri National Youth Council, led by Agbate Yuniro Wayemi, stormed the INEC office in Asaba and insisted that unless INEC obeyed the law, that they would not allow election to happen. That necessitated the Inspector General of Police sending a team down to Delta State, and there was a mediation talk that resulted in a memorandum of understanding. The order of the Court of Appeal striking out INEC's appeal is contained in this book, in the appendix, and that is why I think you should really get this book for the sake of history. Now, that memorandum of understanding, a copy of it is also contained here. That memo was signed by INEC, the Commissioner of Police, and then the representative of the Shekiri National Youth Council, with the promise by INEC that they were going to proceed to effect the judgment. That they never did. A group of young men, after the 2019 election, instituted actions in the tribunal to challenge the legality of elections conducted on the basis of word structures and numbers that have been declared illegal, unconstitutional, null, and void. Again, of course, the tribunal said that it was a pre-election matter, and it was on that strength that the matter could not proceed. Still, INEC refused to obey the said judgment. Then, not knowing, and this is where the fraud, a lot of you hear about Supreme Court judgment, Supreme Court judgment, Supreme Court judgment. You do not know how the Supreme Court judgment came about. INEC now secretly conspired with the Ijos in 2011 and secretly went to court, INEC being a willing defendant. A willing defendant, by the way, is a person who conspires with another person to go to court and agrees that he should be defeated. So INEC then went. The said Supreme Court judgment is what I'm talking about now. Why the Court of Appeal judgment was subsisting about the same subject matter, INEC, who is the judgment debtor, secretly conspired with the judge and went to court. When they got to court, they agreed with the case of the judge from the lower court, and they drove the case up to the Supreme Court without the knowledge of the judgment creditor, the Shekiris. Also without the knowledge of the Robos. The Robos who are brandishing the Supreme Court judgment now do not even know how it came about. This was the fraudulent way in which the Supreme Court judgment came about. I say fraudulent advisedly because whenever you approach a court and conceal facts and misrepresent them, you have acted in such a fraudulent way because the court would not even know. It is what you present to the court that the court will determine. The court is not a forensic laboratory where you start investigating. So, with INEC and the judge conspiring to deceive the justices of the Supreme Court, The Justice Supreme had no way of knowing that INEC was the judgment debtor in a particular case, the same subject matter, over which they had instituted an action and driven it up to the Supreme Court stage. At the appropriate time, the appropriate measures will be taken against the lawyers who did this. But things are nastier than that. The lawyer of INEC, the head of Department of Legal in INEC, who is a senior advocate of Nigeria, T.M. Inoa. Now, mind you, I am a lawyer, so before I come on air to say what I'm saying, and then I know exactly what I'm saying, and I'm prepared to defend. And that's why I've said that if anybody is able to, with the aid of verifiable and credible evidence, impute on the truth of any part of this work, I have pledged a sum of ₦1 million, because I'm confident in what we are putting out there. And so back to our story. They now went to court secretly, and the nastiest thing about it was that while the said T.M. Ilua SAN was going to court secretly with the judge, he was also coming to court with the Shekiris, because the Shekiris had gone to court to try to contempt the chairman of INEC for not obeying the judgment. And so, in 2021, the chairman of INEC, through T.M. Ilua SAN, pleaded. I was a lawyer then. Mind you, when this matter started, I was still a law student. I was just going to court. I was a law student at the university, at the Obafemi Law University, Ile-Ife. Now, I have been practicing law now for over 23 years, and yet, the said judgment has not been implemented, has not been enforced. When all this happened, neither the judge nor the robots lamented that the judgment was not being implemented. And so, in 2021, the chairman of INEC then pleaded that the enforcement procedure, the content procedure that was on in Benin, should be withdrawn, and that they were now ready to enforce the judgment, knowing that the Shekiris was not even aware of the secret case which INEC and the judge had instituted and were pursuing and getting close to obtaining judgment. So the INEC team then prepared a proposal, a legal opinion on how INEC was going to enforce this judgment. Based upon that, the Shekiris withdrew the content proceedings. A copy of that legal advice is also contained in this book. The legal advice is of 12 pages. It is here, and that's one reason why you should get this book. Now, it didn't stop at that stage. It went on. When eventually, a year after they had proposed to settle the matter with the promise to enforce the judgment, they now obtained the judgment in the Supreme Court. Secretly, that was in 2022. Of course, there is the avenue to go back to the Supreme Court and tell the Supreme Court that this is the nasty thing that INEC had conspired with the judge to do. But that is still a possibility that will be explored. In the meantime, not to appear to be afraid of delineation, the Shekiris now agreed and asked INEC, how do you want to do this delineation? Before the Shekiris knew what was happening, the judge and INEC and the robots had gone to Abuja to arrange how the delineation is to be done. Now, the photographs of the Ijos, INEC, and the robots meeting in the FCT at the headquarters of INEC to arrange for the delineation are also contained in this book for you to see. And so you now find that a principal constituent of the constituency was left out in the arrangement. And that was how it was then possible to have a committee that was chaired by an Ijaw leader of thought and with a field officer who is also a member of the Ijaw leaders of thought. Now, it didn't end there. The fraud did not end there. In fact, this whole delineation exercise is a bundle of fraud. Now, when INEC eventually released the proposal for the delineation, it was found out that, what kind of thing is this now? Didn't you tell them I was recording? What kind of thing is this now? Didn't you tell them that I was recording?